you the facts briefly. The South African Court of Appeal allowed an appeal against the conviction of the appellant for treason. The appellant, a member of the military wing of the African National Congress, who had fled South Africa while under a restriction order, had been abducted from his home in Mbabane, Swaziland, by persons acting as agents of the South African state and taken back . He was a member of the military wing of the African National Congress who had fled South Africa while under a restriction order and had been abducted from his home in Mbabane, Swaziland, by persons acting as agents of the South African state and taken back to South Africa, where he was handed over to police and detained in terms of the security legislation. He was subsequently charged with treason in a circuit court. And the appellant had, prior to pleading, applied for an order that court lacked jurisdiction to try the case, as his abduction was in breach of international law and thus unlawful. This is a precedent which is on all fours with this, and the court had the occasion to say this. We note that in this instant case, the state of South Africa violated the territorial integrity of Swaziland by sending its own police to abduct the appellant from Swaziland. The South African Court of Appeal also considered that it had no jurisdiction to try him, given the breaches of international law that South Africa had been privy to. Therefore, they said, therefore, the other Tanzanian case which is cited here is distinguishable from this one. So I invite this General Court Martial to treat that as a redundant submission because it has no basis in the law. And the decision that was made final in that particular matter is what I read earlier, that court has no jurisdiction to try a person who was abducted from another jurisdiction by agents of the state authority exercising power in the area of jurisdiction of the court. That puts this matter to rest, and this is a court, this is a constitutional court whose decision is binding on this General Court Martial. Then regarding the definition of the defense forces and the incurably defective charge sheet, because we maintain it's incurably defective. When you state in the particulars that a pistol and ammunition found in possession of Colonel Dr. Besigye and Obedi at Riverside apartment in Kenya, which is a monopoly of defense forces, Mr. Chairman, it would be stretching the UPDF law to levels of absurdity to state that a weapon found in Kenya is a monopoly of UPDF. That would be absurd. That a pistol found in Kenya is a monopoly of UPDF. That would be an absurd. This is the defectiveness we are talking about in the charge sheet. It cannot be. And it would only be a monopoly of UPDF. And even here locally, by the way, Mr. Chairman, there are authorities to the effect that a pistol is not a monopoly. But those are matters that can be handled at a later stage. It's not a monopoly of the UPDF, a pistol and ammunition. Now, on the question of an MOU, this sounds strange. Wouldn't this submission coming from lawyers who went to the law school and they are here dealing with matters of this nature, brave as they are? Because, Mr. Chairman, we are talking about matters of life and death. And we are talking about an MOU to override a written law. When you look at this act, the Extradition Act, which commenced on the 20th of July 1964, in the long title, Mr. Chairman, it's very, very clear an act to provide for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This is an act. An act, this is the wrong title. An act to provide for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This was not made in vain. This is the only framework we have under the law that can be invoked to have an accused person transferred from Kenya to Uganda. There is no any other framework, legal framework. I wish they cited the law under which that MOU was executed. At least even laying it on the table that this is the MOU. And the law which provides for elaborate mechanisms you have to go through before you get one transferred back to Uganda. And you are saying that one can be jettisoned by a mere piece of paper called an MOU. Mr. Chairman, that should be treated with the contempt it deserves. On my side, the final submission, Mr. Chairman, the issue of Article 2 or Section 208 and 9. Section 208 of the UPDF Act. Mr. Chairman, this law, this particular provision, was not meant to operate in isolation of other legislations. No. It had to operate first and foremost within the existing constitutional order, because the Constitution is supreme. My learned friend here, Senior Counsel, and my brother Kalibara here, they have cited the relevant provisions of the constitutions which are comparing, which take precedence over any other legislation. But even then, the UPDF Act comes into play after you have complied with all these other requirements, with all these other laws, the extradition law, the Constitution, and all this. So that's when it comes into play. But if you cannot cling on one particular provision and say, it gives us universal jurisdiction over all matters worldwide. So the other argument that we have not particularized the defects in the charges are equally neither here nor there. Because, Mr. Chairman, we clearly indicated that the charge sheet, the way it is structured, when you look at it on the face of it, you can see the defects, the charge sheet itself. Because, yes, my learned friends have cited section 6, 7, and 8, which talk about the particulars of the charge sheet. Exactly this is the point we are raising in this amended charge sheet here, where they are stating that in county 4, county 3, and 4, together with actually county 5, where they are talking about rounds of ammunition and a pistol. Here we reiterate our earlier submission. We are saying this particular, these particular counts do not spell out exactly the acts, the impending acts of the committed by the accused persons in regards to the defense forces here in Uganda. This is the point we are making. The impending acts in regards to the defense forces here in Uganda. Let me say it differently. If indeed they wanted this section 2.8 and 2.9 to come into play, they should have expressly stated that they were found in possession with the firearm, with the pistol and ammunition, which are a property of the government of Uganda. If that's what they had said, that would be a different case. That which are a property, subject to proof of course, which are a property of the UPDF. That would be their case. But it cannot be sufficient to say that whoever is found in Kenya with a pistol and ammunition, he offends the UPDF Act. There are so many people in Kenya right now with pistols and rounds of ammunition. Would they want to suggest that those are all subject to martial law here in Uganda? This is the absurdity we are talking about in this country, that it's not particularized, and it is duplex in nature, that it purports to bring all these issues of ammunition, of the pistol and whatnot, all lumped together to make it as if it's one count which is put here. So basically, on the question of evidence, as I wind up, Mr. Chairman and honorable members, that we should have laid evidence before you regarding the way they were transferred here. Mr. Chairman, the charge sheet speaks for itself. The record is very clear before you that all they are complaining about, all the issues they are raising, Kenya, Switzerland, and elsewhere, there is no single impande act here that offends the law which they are putting in particular of the charges, of the charge sheets. Nothing. So all they are talking about are acts which are alleged, which are alleged to have been committed in Kenya. And in this particular case, Mr. Chairman, and in this particular case, Mr. Chairman, we want you to find that these acts complained of here can only be, first of all, processed by those respective jurisdictions. Kenya, Switzerland, or Greece, but not to be directly brought here before you. I ask my colleagues if there are other specific issues to respond to. Okay. I thank you, Mr. Chairman.
Just a single issue in your commission. The prosecutor says that